Watch this video to see what Ripple's CEO has to say about the SEC case. As XRP prices go through the roof in Wales, the company's CEO, Brad Garlinghouse, has said that he doesn't agree with the SEC's position on XRP. Market data shows that big cryptocurrency holders are changing their minds right now. The CEO's comments come at a time when Ripple and the SEC are in a legal battle that won't end, and the actions of the regulator are getting the attention of experts in the field on X. Brad Garlinghouse was unhappy with the recent actions of the Securities and Exchange Commission. He said the following: a new low for a renegade agency most people thought couldn't sink any further, despite a court's decision that XRP is not a security. SEC, which stands for the Securities and Exchange Commission, now says it may be able to do things that are against the law. The CEO's comments show the ongoing conflict between Ripple and the government agency, which has been the subject of a lot of discussion in the cryptocurrency industry. Additionally, Garlinghouse said that the Ripple team would be closely monitoring events and considering our own options to hold the SEC accountable. Based on this comment, it seems like the company is thinking about making more legal or strategic moves in reaction to the SEC's plan to control XRP. There has been a huge increase in the buying of XRP by big holders, who are commonly known as whales in the cryptocurrency world. This is happening even though the law is still not clear. That's why Ripple is pursuing the case over the sale of XRP tokens and has filed an appeal on a cross-appeal in an ongoing litigation. Ripple has filed a cross-appeal against the U.S. Securities and Exchange Commission, and the company plans to document all of the case's relevant legal issues in response to pressure from the SEC. This month, this measure was put into place, and he started the process of filing an appeal notice. Ripple Labs CEO Brad Garlinghouse and its executive chairwoman Christine Larson filed a cross-appeal. Federal Securities and Exchange Commission appeals second stage August ruling by Judge Annalisa Torres that XRP tokens traded on secondary markets by Ripple were not securities. In December 2020, the U.S. Securities and Exchange Commission started legal proceedings against Ripple because the company had sold securities without properly registering. The lawsuit has become a hot topic in the Bitcoin niche. At that time, Ripple's public offering of XRP sales to other countries did not violate securities laws according to Judge Tease's ruling from August 2023. On the other hand, a $125 civil penalty was imposed against Ripple for purchases made by financial institutions. This was a big increase from Ripple's original request of $10 million. As soon as the Securities and Exchange Commission sent the October warning, Ripple decided to file a cross-appeal. Stuart Alderoty, a top lawyer for Ripple, said that the cross-appeal will help make sure that important problems like what an investment contract is won't be missed again. Ripple is still fighting the SEC's claim that XRP is a security offering, and the company is responding to the SEC's appeal with more objections. On October 10, 2024, Ripple filed a cross-appeal in response to the U.S. Securities and Exchange Commission's appeal from earlier this month. This particular legal battle has not yet come to an end, and by filing this cross-appeal, Ripple has joined the SEC, and their cases will now be handled as one. Ripple is challenging the government's decision. In its cross-appeal, Ripple wants to overturn the court's ruling that selling XRP to investors did not break any stocks laws. The court's order for Ripple to pay investors $125 million for XRP is what started this movie. The SEC had originally asked for a $2 billion fine, so this is a big drop, but it is still a lot more than Ripple's $10 million offer as these events continue to play out. Stuart Alder, Ripple's chief legal officer, wrote a tweet that got the attention of the cryptocurrency industry. According to a post by Alderoty on X, the SEC has apparently filed an appeal because it failed on all the relevant grounds to make sure that all parts of their legal dispute with the U.S. Securities and Exchange Commission have been dealt with. Ripple just recently sent a cross plea, which is different. Aldara thinks that the SEC might say that selling XRP on several platforms and giving it to developers and workers should be seen as securities. He was optimistic about Ripple's chances of success because of the previous court's decision. Now, he's crossing his fingers that the current court will reject the Securities and Exchange Commission's recent efforts, especially those led by SEC Chair Gary Gensler in light of these events. Brad Garlinghouse, CEO of Ripple, stated that the U.S. Securities and Exchange Commission (SEC) is more focused on causing disruption and confusion within the cryptocurrency industry rather than providing clear regulatory guidelines. He added that Ripple aims to put an end to the SEC's practice of regulation by enforcement. Ripple, the company behind the XRP cryptocurrency, has now filed a cross-appeal in its ongoing case against the SEC, signaling its intent to take the legal battle further. The cross-appeal was filed with the U.S. District Court for the Southern District of New York and marks an important step in the legal process. A cross-appeal differs from a typical appeal in that it is filed in response to the opposing party's appeal, allowing Ripple to challenge additional aspects of the court's ruling. This move shows that Ripple is not just defending itself but is also actively seeking to overturn certain unfavorable parts of the case. Judge Torres, who is a district judge for the Southern District of Newark, made a decision that both Ripple and the SEC are reviewing. In the past, there were 13 federal appellate courts that looked over decisions made by lower courts. Stuart Allen, Ripple's chief legal officer, said that the appeals will be heard by the Court of Appeals for the Second Circuit. The company has taken all the necessary steps by making a cross-appeal today as part of the cross-appeal. A Twitter user named X said that an investment contract must include basic rights and responsibilities. The SEC will not be appealing the decision that XRP is not a security, as Brody and Alderodi testify. Ripple's chief legal officer even said that the company regrets labeling the token as a security. According to Alderodi, the SEC may try to overturn the decision that Ripple's automated XRP sales and other distributions did not constitute securities, but he thinks that the SEC will fail again on this issue. In 2020, the U.S. Securities and Exchange Commission sued Ripple Labs, saying the company had made $13 billion selling XRP tokens that the SEC said were not registered securities. In August 2024, Christian Larson, co-founder of Ripple, and Brad Garlinghouse, CEO of Ripple, were both sued in a divided court decision that could lead to direct institutional sales of XRP being considered possible unregistered securities offerings. Still, this doesn't include programmatic sales or other distributions like those made to pay developers and employees. Retail investors didn't know if they were buying XRP from Ripple or another vendor, which is why the choice was made to prefer Ripple for programmatic sales. This means they failed the Howey test, which says they should have had reasonable expectations about the company's ability to make money. Ripple Labs was told by Judge Torres to pay a total of $125 in fines. The money from selling XRP directly was used to make an estimate of these charges.